Welcome to this explainer. Look, if you've ever felt totally overwhelmed by the mere thought of navigating the legal system all on your own, trust me, you are definitely not the only one. Trying to resolve a nasty dispute or just collect money you're rightfully owed can feel like getting trapped in this impossible maze of confusing paperwork and procedural dead ends, especially if shelling out for an expensive attorney just isn't an option. But hey, it really doesn't have to be that way. Today, we're providing a clear, empowering map to help you seek justice on your own terms. We're going to demystify the entire Utah small claims process step by step, using the state's very own laws, court rules, and official guidance.
You know, the frustration you might be feeling right now is actually a widely recognized systemic issue. Back in his 2022 State of the Judiciary address, Utah Chief Justice Matthew B. Durant literally called this the access to justice gap. He pointed out that everyday legal problems, like disputes over debts, contracts, property damage, they're basically as inevitable as death and taxes. Yet for most folks, getting professional legal help is just flat out too expensive. So, the small claims system we're exploring today, it's one of the judiciary's absolute best solutions to help bridge that gap, giving everyday people a direct, accessible path into the courts.
All right, so here is our exact game plan for today. We'll quickly run through 1. Understanding Utah's small claims, 2. Preparing to file, 3. Filing and serving papers, 4. Dispute resolution and mediation, 5. The actual court hearing, and lastly, number 6. Judgments, appeals, and next steps. We'll cover everything from how the court works in gathering evidence to exact fees, going to trial, and what happens at the end.
Okay, jumping right into Section 1, Understanding Utah Small Claims. Let's just quickly define what this court actually is. At its core, it's a streamlined, incredibly informal system designed specifically for speedy justice. You know those super rigid rules of evidence and procedure you see in massive corporate lawsuits on TV? Yeah, those are heavily simplified here so that you can confidently represent yourself.
Now, before you even think about filing, you got to know if your case actually fits the financial limits. Right now, the maximum amount you can sue for in a Utah small claims case is $20,000. But here's a really fascinating detail. Utah operates on this totally unique statutory escalator to combat inflation. So, while the cap is $20,000 today, that limit is already legally scheduled to just automatically bump up to $25,000 on January 1, 2030, without the state needing to pass a single new law. Kind of cool, right?
However, there are some pretty strict rules about what you can actually ask a judge to do. Small claims court is all about the money. It can only award money. You absolutely cannot use this court to force someone to return a specific piece of property or perform a service. On top of that, no eviction case is allowed here, and you are entirely prohibited from suing government agencies or government employees for things they did on the job. So, if your dispute doesn't fit these specific parameters, you'll unfortunately have to look outside of small claims court.
Moving right along to Section 2, Preparing to file. Look, walking into court without doing your homework is basically a one-way ticket to getting your case dismissed. Before you fill out a single form, meticulously tracking your deadlines and getting your facts straight is absolutely essential.
The clock is officially ticking on your right to sue. This is what lawyers call the statute of limitations. For a written contract, you have exactly 6 years from the moment the contract was broken to file. Interestingly, Utah uniquely lumps oral contracts and personal injury claims under the exact same 4-year limit. General property damage claims? Those are tighter. You've got just 3 years. Miss these windows, and your case is legally expired. Just poof, gone.
So with your deadline in mind, it's prep time. Now, while the law doesn't strictly force you to do this, it is highly recommended that you send a formal demand letter via certified mail at least 30 days before you file. Why? Because judges really want to see that you made a genuine good faith effort to work it out before dragging everyone to court. While you wait on that, get your evidence together. Dig up the contracts, the receipts, print out those photos, save those text messages. Judges expect hard, concrete proof, not just your word against someone else's.
All right, on to Section 3, Filing and serving papers. This right here is where the legal process formally kicks off, and honestly, it requires absolute precision on your end. To officially start your lawsuit, you have to file an affidavit and summons and, of course, pay a filing fee. Utah uses a tiered fee system, so it depends on how much you're asking for. It's going to run you $60 for claims up to $2,000, $100 if you're asking for up to $7,500, and $185 for anything up to that $20,000 maximum. And here's the kicker. You can't just file your paperwork at whichever court is closest to your house. You have to file in the specific justice court where the defendant lives or where the actual event that caused all this drama went down.
When you're filling out the official forms, getting the defendant's exact name and address is vital. That address completely dictates your jurisdiction. If they live in a city that has a municipal justice court, boom, you file there. If they live out in an unincorporated area, then you file in the county justice court. If you mess this part up, the judge might throw your case out simply because you filed in the wrong building.
Okay, so you filed the paperwork, great. Now you must legally notify the defendant. This is called serving the papers. First off, make copies of everything. Then you have to serve the defendant, but you can't just hand them the papers yourself. No way. You usually have to hire a constable, a sheriff, or use a very specific court clerk mailing process. And watch your calendar closely. There's a hard, non-negotiable deadline. The defendant must be served at least 30 calendar days before the trial date. After they get served, you have exactly 10 business days to file your proof of service with the court to prove you did it right.
Let's transition to Section 4, Dispute Resolution and Mediation. Because, surprisingly, before you ever step foot inside a physical courtroom, Utah courts often require, or at least strongly offer, alternative ways to settle your dispute amicably. It saves everyone time and gives you way more control.
Depending on where you filed, you might be automatically routed into something called Online Dispute Resolution, or ODR for short. Chief Justice Durant playfully calls this pajama court. It's basically an asynchronous online platform where you and the person you're suing log in and use a neutral facilitator to try and negotiate a settlement right from your laptops. In a lot of major jurisdictions, participating in ODR is actually mandatory, unless you officially request to be excused because you don't have internet access, or maybe you have a disability or a language barrier.
If you aren't funneled into ODR, lots of courts offer free small claims mediation. And honestly, mediation is incredibly advantageous. When you sit down with a mediator, you can craft totally flexible, legally binding solutions. Remember earlier when we established that a judge can literally only award cash? Well, in mediation, you and the defendant can agree to whatever you want. A payment plan, trading property, agreeing to finish a job. If you hammer out an agreement, the judge simply signs it, makes it a binding order, and your case is dismissed. No stressful trial needed.
Section 5, the court hearing. But what if a settlement just isn't happening? Well, then it's time to face the judge. This is your one big opportunity to lay out your case.
Now, on the official summons that gets handed to the defendant, there is a very dire warning that applies to absolutely everyone involved. It essentially says, if you fail to appear, judgment may be entered against you. In small claims, attendance isn't optional. It's mandatory. If the defendant flakes and doesn't show up, the plaintiff can win by default. If the plaintiff doesn't show up, the judge is probably just going to dismiss the whole case. Bottom line, whatever you do not miss your trial date.
When trial day arrives, your preparation is everything. So here's a quick, actionable checklist for you. Number 1, the rule of 3. Bring exactly 3 copies of every single contract, receipt, and photograph, one for the judge, one for the other guy, and one for yourself. Number 2, if you have witnesses, they actually have to show up in person. Handing the judge a letter your friend signed usually won't cut it. Number 3, rehearse a clear, factual timeline. And lastly, stick to those facts. Judges decide based on hard evidence, so you've really got to keep the personal grudges and the intense emotions out of it.
It's also super important to know that small claims trials are what's called bench trials. That just means the judge listens to both sides and decides the case all alone. There is no jury box. Now, if a defendant really strongly wants a jury trial, they do have a way to get one, but the window is tiny. They have to file a notice of removal to pull the case out of justice court and kick it up to district court. And they have to do it within exactly 15 days of being served the initial papers.
Which brings us to our final stop, Section 6, Judgments, Appeals, Next Steps. Let's look at what actually happens after the judge bangs the gavel, whether you win or lose, and how you handle the aftermath. Say you lose, and you completely fundamentally disagree with the judge's decision. You do have the right to appeal, but a small claims appeal in Utah is unique. It's called a trial de novo. Basically, it's not just some higher court checking the paperwork for typos. It's a completely fresh, brand new trial in the district court. You get a clean slate, but it means you have to bring all your evidence and witnesses and present the whole shebang all over again, and you have exactly 28 days from the date of the judgment to file for it.
But what if you win? Awesome. But here's the reality check. The court doesn't actually collect the money for you. It's entirely on you to initiate the collection phase if the defendant stubbornly refuses to pay up. The silver lining is that your unpaid judgment actually earns interest while you wait. Utah law sets this post-judgment interest at the federal rate plus 2%, which right now hovers around 7%.
If they still dodge you, you can pursue bigger legal tools, like garnishing their wages or putting a lien on their property.
Okay, before we completely wrap things up today, I do need to give our standard professional disclaimer. Everything in this explainer is strictly for educational purposes only. Laws and procedures constantly change, and obviously, every single case has its own quirks, so this information is not a substitute for professional legal counsel regarding your specific situation. We highly advise you to consult with a qualified Utah attorney or a local legal aid organization before making any serious legal moves. But at the end of the day, remember this. Small Claims Court was literally designed for you, the everyday citizen, to have a voice and a practical venue to seek justice. Yes, it takes some serious organization, strict adherence to deadlines, and keeping a cool head in front of a judge, but it is entirely within your reach. So, knowing what you know now about the financial limits, the paperwork, and the strict timelines, are you ready to gather your facts and finally take that first real step toward resolution? Thanks so much for joining us for this explainer, and we will see you next time.